to mention item number 20, my lord, on behalf of MS N. Soikia, my lord.
Yes.
This matter may be listed after 1 week, my lord.
20.
Yes, my lord.
16 matter.
My lord, she has got some personal difficulty today.
Other
unable
side
to
has
come.
been informed.
Yes, my lord, she has informed.
A request has been made on behalf of MS and Learned Council for the appellant for a small, for a short adjournment. Considering the same, accordingly, the matter can adjourn to be listed when
My lord, next week, any date, my
after
lord.
a week.
May it please your lordship. May it please
Yes,
your
yes.
lordship. I beg to mention one IA lordship. It is pending since 2020.
for
IA for injunction lordship. At the time of filing RSA, we have filed one injunction petition. Notice was issued lordship. But in the meantime, they have started
other side
construction.
have appeared.
Yes, lordship.
When do you want?
Friday lordship. And another review matter, in that review matter, I am for the respondent lordship. Court directed to withdraw the amount 3 lakh submitted by the petitioner, but to what extent it is to be withdrawn by each of the respondent, that was not mentioned. For that
Clarification.
lordship. Friday lordship.
Let us pray. But this week, second half, we'll have difficulty in sitting. There is some interview process where this court is involved.
Thursday, Friday, any date.
Ideally, next week will be better, but we'll see Friday.
Lordship. Apply. Okay.
I beg to
Just a
mention,
minute. We can also explore the possibility of sitting extended in the first half till half an hour so that we can do maximum work as possible. Second half may not be possible. Okay, yes.
May I please your lordship, my lord, I beg to mention item number 2 to 7 lordship. Lordship, here I am for NCT lordship. So lordship, we require to file an affidavit lordship, which already sent lordship for betting lordship. So kindly this matter may be taken up on 7th or 8th of August.
Other side informed.
Yes, lordship, they are already sent.
Standing Council NCT has submitted that the affidavit in opposition would be filed shortly. Shortly, and therefore he prays for some time. Could publish after 2 weeks. 2 weeks. Are these top of the list matters?
Yeah.
2 weeks.
Hi, lord.
may it please your lordship. I beg to mention item
No,
number
we
9.
fixed the date. We fixed the date. Top of the list matter. Since these matters have been specially assigned to this bench from alert, these let the next date be fixed on
8th of August, lordship, on a hearing day, lordship.
8th of August.
8th or 10th,
When will you say?
8th of August.
8th of August.
Sure.
8th, you can file it by 8th.
Yes, lordship.
In all the cases, lordship.
No, lordship, issue is similar, lordship.
8th of August.
Obliged.
Like,
May it please your lordship. I beg to mention item number 9, my lord. For Rana Senior Consensus C. Goswami. He is out of station, my lord. So matter may not be taken up today.
Okay, okay. It is submitted that Sri C. Goswami Learned Council for the petitioner is out of station. List after a week.
All
May I
right.
please, Lordship. Lordship, I beg to mention for listing of an FAO along with one IA for injunction. Lordship,
FAO, fresh matter.
yes, Lordship.
When do you want?
Can it be tomorrow or day after tomorrow?
Tomorrow, not possible. When did you file?
Yesterday, Lordship, there is some urgency in the matter because already on two occasions, the respondents have tried to dispose the appellant.
On Friday.
Friday, Lordship. Much obliged, Lordship.
May it please your lordship. Your lordship, with the consent of the other side, I beg to mention item number 24, your lordship.
Yes.
Your lordship, I am appearing on behalf of RK Bhuya, your lordship.
Yes.
Lordship, maybe adjourned for a week, your lordship. This matter.
Take the consent of the
Consent
other side.
taken, your lordship.
24 of the supply list.
Lordship.
Other side has been informed
Your lordship, informed.
on a prayer made on behalf of the applicant matter is adjourned to be listed when?
Next week, your lordship.
Listed
Any
for a
date.
week. 1 week, yes.
Much obliged.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 16 of daily list, my lord.
Yes.
My lord, here I have recently entered appearance on behalf of the appellants, my lord. May I pray an adjournment? for-
Recently appeared when?
My lord,
When was the recent appearance?
recent, my lord, 2 months back, my lord. Last week I have been handed over the brief, my lord.
You were not there earlier.
I'm not there earlier, my lord, 2010 matter. My senior was there earlier, my lord. So may I pray, my lord, I may.
Other side has been served or not? It's for hearing.
Sir, my lord, they had not appeared, my lord.
When do you want?
After 2 weeks, my lord.
Not after 2 weeks. 2010 matter. Next Tuesday. Next Tuesday.
Not next week, not next week, my lord.
We cannot adjourn a matter of 2010. We are accommodating you for your difficulty, but we cannot adjourn like this. We'll have it next week, next Tuesday or next Thursday.
Next Thursday, my lord.
Sri M.K. Sharma, learned counsel, submit that he has entered appearance on behalf of the appellants recently,
It may be on Tuesday, my lord. No,
recently, and praised for some time. Put up. However, considering, considering that this arrest is of the year 2010, a small accommodation is granted, directing listing of this matter on Tuesday next. Date to date.
Second of
First of August. 1st of August.
Obliged, my
May I please, your lordship?
Chavroti?
My lord, item number 26, my lord, this is an arbitration appeal and for the railway. There is an order for getting the arbitration reports of the arbitration proceeding, my lord. I received the record today in the morning, my lord. I need some time to go through it, lordship, and can take up this matter on Tuesday.
Oh,
I'll inform Halon, my lord.
You have not informed.
I'll inform definitely, my lord. I was unsure.
We will not make an exception.
My lord,
We'll
yesterday,
grant you the adjournment, but not now.
can it
we'll
be taken
grant
up on Tuesday, my lord?
We'll grant you, but we're not passing the orders now. In his absence, we are not passing the order.
Right.
You have somebody in the court?
Right.
Or you try to contact him right now till the mentions are over? Without consent, I'm not going to pass orders. Yes.
May it please your lordship. Your lordship, with due consent from other side, I beg to mention item number 21 of today's list, your lordship.
Yes.
Your lordship, counsel representing the case has some health issues, your lordship. My prayer is that this matter may kindly be taken up next week,
You are for the respondent.
lordship.
I'm for the appellant, lord. My consent.
Okay. Madam, you're Gustami.
Lordship,
No.
appearing for the payments, your
Yes.
lordship.
Okay. A prayer has been made on behalf of respondent number 6.
Respondent number 1 to 3, your lordship, claimants.
Respondent number 1 to 3
Yes.
for an adjournment on personal grounds. Full stop. Sarah, next week,
Next week, any date, your
list next week.
object.
My lord, I beg to mention for listing of a regular second appeal for orders, my lord, maybe on Friday, my lord.
This week, as we have told, we have some difficulty. Let us try, but we have it on Monday next.
My lord, I've informed him.
Item number
26.
26.
On Tuesday, my lord.
Priyash Chakraborty, Learned Standing Council Railways submit that record of the arbitration proceedings have been received only this morning, and he accordingly praised for some time. List after a week.
First, my lord, next Tuesday,
List on Tuesday next.
1st of August.
List on first of all.
May I please, your lordship? Lordship, I beg to mention for listing of a CRP, lordship. There is an interim, lordship. Can it be on Friday, lordship?
CRP at the stage of what? Motion?
Lordship.
Motion matter.
No, lordship, admission. Lastly, it was posted on 36/2023. There was an interim, lordship.
There was an interim order.
Lordship. If
You're
not
protect-
posted,
You're protected.
Lordship, it is returnable within 4 weeks. And on
Doesn't
28,
matter. Has any date been fixed? No date has been fixed.
no, Lordship.
It should not be voted. If it is not listed, not your fault. Unless it is limited by a date. Don't worry, it will come on soon.
Obliged.
May it please your lordship. Lordship,
You
I'd
can
like-
have it next week. Give next Wednesday or something, but no urgency. Yes.
Lordship, I'd like to mention item number 8 for adjournment.
8.
Yes, Lordship. Lordship, I've informed the private respondents. However, there is Department of Elementary Education whom I have not informed. I will inform them.
So, madam, inform them.
Yes, Lordship, I will
Without
inform.
information, we are not going to pass
Yes,
orders.
your lordship.
Yes, somebody is there.
Lordship.
Item number 8.
Yes, Lordship.
A prayer for adjournment has been made on behalf of the petitioners. This is top of the list, isn't it?
Yes, Lordship.
Why are you taking time today?
Lordship, my senior has some personal difficulty. It is just cropped up. So, Lordship, I'll have to.
Your name, madam?
And Begum.
MSN Begum Leonard Council submit that her senior KK Mahanta could not appear because of some personal difficulty. Full stop. Also heard P. Bora, Leonard Training Council, Elementary Education Department. Full stop. Though this matter was fixed today, as this court was informed about some urgent, considering the request of personal difficulty, the matter is adjourned to be listed,
Next week, Lordship, any date.
listed, we fix the date.
Yes.
Because this is out of turn matter. On 3rd of August.
Yes.
3rd of August. But Mr. Bora, take a note, this is not the regular bench. 3rd of August.
Lordship. Lordship, there is an interim order. It may take some
Interim order passed today to continue till the next establishment.
time.
Yes.
It's for the open number 67.
May I pray for listing of a MSc appeal with delay condemnation petition? Any day in the next?
Press
Hello?
Press matter.
No, my whole matter, man. 2017.
Delay condemnation, delay is yet
Yes.
to be condoned. Yet to be condoned.
No, my lord. Yet to be condoned.
Why?
Pending matter, my lord,
17
notice
matter.
could not be served upon the respondent number 2 and 3, my lord.
Okay, next Monday.
Next Monday. My lord, then my lord, 31st.
Yes, for 31st.
Obliged, my lord.
I begs permission for listing a RFA, my lord. This is a old case, my lord, 2017 case. In spite of repeated mentioning, that case has not been listed.
It is at what stage?
My lord, regular first appeal.
What is the stage?
Stage hearing, my lord.
Hearing.
In
Have
fact,
it
my
for
lord,
order.
it was listed in the part 1 list before, my lord.
Have it for orders on Monday next, we'll fix up your hearing.
My
31st.
31st.
It'll come up in the orders column.
My lord.
Just mention, we'll have it for hearing. 20.
May I have the lordship, my lord, before starting argument on merit, I want to apprise this honorable court, my lord, that regarding the virus of 2017 Act, some writ appeal is pending to quash the said, strike down the provisions of those act. That is this is the order of writ appellate court. Whether lordship would proceed on or will wait for the. That
Is
is
it, your matter is connected with the
Yes.
17 Act?
deeply correct.
This fixed on hearing for in due course. This appeal is fixed for hearing in due course.
Then we have to take it. Because it is top of the list.
No, we have no objection, but
Yes, yes.
bunch
No,
of writ
it is
petitions.
good that you have informed us. We'll have that thing in mind.
Now, my lord, here, my case is like this. I am Jorina
Zarina Khatun.
Khatul.
Yes.
My appointment letter may be seen page 19
As
as assistant teacher, page 19.
19.
So, my lord, at the initial stage,
Just a minute.
19.
This is dated 15 February.
It is dated 15 years, 15 February 2006. But though I am assistant teacher, but I am a social science teacher, that may be seen page 41, my lord.
What is the name of the school? Dustin
Kumullipara,
Mulipara.
ME Madrasa.
Can we have a look at the writ appellate order? What was it?
So, Lordship,
Mr. Mahmood, can we have a look at that order you're trying to? Mr. Sheikh is appearing for whom?
I'm for the teacher whose service has been credentialed.
You're for the private respondent.
Yes, sir.
now, Lordship, kindly see page 41.
Just a minute.
Some pages are missing. This volume now. Only the relevant part.
Relevant portion of the order we have provided.
Yes.
Page 41, kindly see.
41.
41, yes. Alia Khanum,
41.
Alia Khanum, she is the teacher one, that is the headmaster, headmistress.
41. Alia Khanum.
Yes,
Okay.
she is the headmistress. And Jorina Khatun, Lordship would see, Jorina Khatun,
This
socialist.
list was sent for provincialization.
Yes, tutor as tutor. Jorina Khatun, she is social studies teacher.
Where do you get?
Serial number, right side, serial number 8,
Okay.
social study teacher.
Hmm.
Then Lordship kindly see page 45.
What is your name, Mr. Sheikh?
No.
Your name?
Alia Khanam,
R?
headmistress.
RR?
Respondent number 789.
7 and 9.
No, who is the Alia Khanum is the R what?
Alia Khanam is 9.
9.
By name.
And who are 7 and 8?
With the, that is also by secretary. And 7.
7 is the school.
7, 8, 9. 7 is the headmistress.
Okay.
Now, it is made respondent like this.
Okay, okay.
7, headmistress, come secretary, Dokhin Kumiliapara, Emi Mother.
Okay, come secretary.
8, Dokhin Kumiliapara, Emi Mother, are represented by president. And 9 is Alia Khatam Daike.
Okay.
Tutor of 1506 number posting.
9 is Alia
Alia
Khanum.
Khanam, tutor of 1506 number posting. Paniapara.
But you are also the headmistress. You are also the headmistress.
Headmistress. Here, my lord, it is the basis. That Paniapara, Pochim Paniapara LP school, it is the basis school. Where my I have been headmaster. After
Now we will come to it. We don't know the fact.
yes.
Okay. Then
So, admittedly, my lord, Alia Khanum is the headmistress.
where is it written?
It is written in page 41, then 45, kindly see. Page 41, Alia Khanum.
Yes, where is it written? Headmistress? Yes, head teacher.
Yes, head teacher. And Jorina Khatun, she is social science teacher,
Yes,
social
yes,
study
and
teacher.
serial number 8.
Yes. Then Lordship may kindly see page 45. This is the list prepared by Alia Khanum herself.
40.
45. Here, Alia Khanum, she herself identifies as headmistress. Lordship has said?
This is formed by the headmistress.
Yes, headmistress.
Prepared by the headmistress and
By headmistress. And my name is there in serial number 3.
R9 is headmistress.
headmistress.
Okay.
Now kindly see serial number 3, Jorina Khatun. She is social science teacher.
Yes. Assistant teacher, social science.
Social science teacher.
Okay.
Now kindly again come to page 43, my lord. 43.
43.
Alea Khanum. Page 43, operative portion, page 44.
Hmm.
Bottom kindly say, I, Sri Alea Khanum, wife of Ainal Haq, resident of village Golia, post office Goremari, district Barbata, now working as headmaster.
Okay.
Then kindly come again, page 32, my lord. This is the teachers list,
Have you seen?
page 32.
Right.
Page 32, Alea Khanum is the headmaster. That's good.
Where?
Alea Khanum 2009-10. This is most very important because Lordship is there as per the 2011 Act.
Where is the headmaster written?
Number 1 is headmistress.
No, where is the headmistress written? Her name is there.
Category 1, kindly see right side. Category 1 is headmaster. First Alea Khanum, then 2 6 to 10 category 1. Category 1 means says here in the bottom there is the introduction of alphabetical manner. The headmistress is 1. Serial number 3 kindly see bottom of page 32. Head teacher 1. Lordship has seen.
Yes,
Head teacher 1.
yes.
Now kindly see my name appears at serial number 6, Jorina Begum.
Hmm.
Now Jorina Begum, she is written as 3. Now 3 is the social
Para teacher.
other
Teacher.
teacher. Assistant teacher, but assistant teacher should be treated as social science teacher because there are 3 subjects: social science, language, and mathematics. So language and mathematics, I have no objection. Those 2 posts have been provincialized as tutors, to which I have no objection. But objection is regarding Alea Khanum, because she is the headmistress. And as per section, let's see, the 2014 Act, 2017 Act, here, page 111.
Of this new book.
This is the book.
111.
Yes.
You are referring to the 17 Act. You're referring to the 17 Act?
2017 Act. Here, Lordship would say, in case of venture upper primary school, there shall be minimum 3 teachers or tutors at least 1 teacher, each for social science and mathematics, social studies and language, provided that for additional posts, it shall be considered in accordance with the norms and standard stipulated in the schedule under section
You are reading which part?
11.
Section 3.
Section 3,
Subsection 11.
subsection 11.
Just a minute.
So here,
Just a minute. 3.1.11. 3.1.11. In case of venture.
well, In case of Venture,
Isn't it 3-1-11?
yes, 3-1-11. So
Minimum 3
the
teachers.
minimum teacher, minimum student, that is in another place it is mentioned. If there are number of students are 100 or more, then there may be a post of headmaster or headmistress. But in this particular skill, there is no students up to 100. So there is no post of Alea Khanam.
Minimum 3 teachers or tutors. Science, number 8, science and math.
Schedule, there is a schedule, my lord. In schedule, it is mentioned, up to 100, above 150 children, there shall be a headmaster's post. That is in the schedule. That is, of course, not our case. Our case is this: she is totally having the post of headmistress, and headmistress has no post.
No, but Mr. Pamut, the question which will arise is that what is her substantive post? As a teacher, she teaches what? Headmaster, headmistress is an administrative job.
Yes.
That's a different thing.
Yes.
But she also performs as a teacher, doesn't she? What is her subject of R9?
Generally, my lord, she is monitoring authority. So the social science teacher, this is their submission, but where is the record?
According to them, they also claim to be a social science teacher.
Claim, but she
And
herself prepared the list.
Yeah, and in the seniority issue, who's senior?
Senior is in the category. Senior,
No, as a social science teacher,
yes.
let us assume he.
I am the only social science teacher.
No, let us assume Mr. Sheikh is also a social science teacher substantively.
Yes.
Leaving aside, then if we evaluate the seniority.
In that group, she is senior.
Okay.
In
But
that group,
your case is that her post is the post of a headmistress.
a substantive post is headmistress, and my substantive post is social science teacher.
And her recognition will come only when the number of students is more than 100.
100, yes.
Since the students are less than 100,
So
the question of
she has no
his
post.
provincialization will not.
She has no post. And everything was prepared by herself. She never said that earlier that I am the senior most social science teacher. That she never claimed. She always said I am the headmistress. Now again, Lordship may kindly see page 19, my lord. 19. So all the teachers are SCN teachers. Subsequently, they are distributed according to their subjects. So there is no problem in that regard, madam. There is no problem in that regard. And my post has remained untouched. Always it remained untouched as social science teacher. And she also never claimed, that is very important thing, madam. She also never claimed that I am the senior most social science teacher. That's why I have a better claim over the writ petition. So that is not her case. Now, Lordship, departmental recognition is there, dice code is there. I am social science now. Lordship, kindly come to page 33 again. This is the data capture system. Here, Lordship would see operative portion. Page 41. Page 41. The Jorina Khatun, social science teacher. This is the last last but most important document.
We have seen this,
Yes,
you have already brought this to.
yes, yes. Now Lordship would see improved order of provincialization. That Lordship may kindly see page 46, right?
46.
46. Here, this is the order. At the name of the Alaya Khanum appears. Name of Alaya Khanum appears at page 51. List of provincialization. Alaya Khanum.
Serial number.
Serial number 140, page 51. Now this is the order. This is the order dated 4/2/21.
Where is which serial number?
Serial number 140.
140.
140, yes. So Alaya Khatun is appointed as social science teacher at nearby Dakshin Kumullipara ME Madrasa. Now, whatever the name may be, but thing is this, she has been taken up as social science teacher. And this order was passed by the Director Elementary Education on 4/2/2021.
Serial number 140 is serial, respond number 9.
That's number 9, yes. Serial number 140.
What about 141?
141, we have no claim because
Nazmul is what? Science
yes,
teacher.
science teacher, yes. We are only against Alaya Khanum. She should be replaced and I should be included. Now, this order of provincialization was passed on 4/2/2021. Now, the last one, the Educational and Personal Qualification of Teachers, Tutors. Last one is dated, my lord. It is dated 5/6/2017. Page 45, bottom left side.
Last one means
45, bottom left side. It is prepared by Alaya Khanum, dated 5/6/2017. So in between there is no communication that she is the social science teacher. So 3, 4, 3, hardly it is 3 years, 3 years, less than 3 years, I think.
In this page 45, the list which you are emphasizing has been prepared by Mr. Sheikh. In column number 12,
Yes.
Mr. Sheikh's client has said that he teaches English and social science.
Yes, I am teaching social science.
No. Alaya Khanum.
Alaya Khanum, page
Page 45.
45.
45, which you are submitting that this is prepared by Alaya Khanum herself.
Social science,
She teaches-
English and
she has
social science.
Described herself as a head teacher, headmaster. But in column number 12, name of the subject taught English and social science is mentioned.
Yes, ma'am. But that is new discovery, man. Because English is a language and social science is not language.
Correct.
So language teacher, there is separate provision for language teacher. So language teachers posts have been already tutor. It is provincialized as tutor. So she cannot claim 2 posts, English as well as social science, because there are 3 subjects: social science, English, and
Science, maths.
maths.
Science, maths. Yes.
Science and mathematics. Now, if a person takes the 2 posts, English and social science, she claiming 2 posts. And this claim of the respondent number 9 does not tally with her earlier communications. This is at a very new discovery. In Dice Code, there is no such mention. Dice Code, Lordship, we kindly see, page 41.
Page?
Yeah, page 41. Here, I am in serial number 8, right side, Zorina Khatun.
Right.
Right side, serial number 9, social studies. I am social studies teacher. And Alaya Khanam is, she is claiming Assamese. She is claiming Assamese. So, this 41 and 45 are totally contradictory with each other. It appears that she did this only to get her post provincialized. My lord? Am I clear, my lord?
Absolutely.
Because 41, she claims as to be an Assamese teacher.
Mr. Mamu, do you, if you come to page 45,
Yes.
is your case, the foundation of your case, that even if we go to the substantive post, then Alia Khanam is a language teacher.
Language teacher.
And there is a language teacher, Mahar Ali, who is much senior to Alia Khanam. So she cannot compete with Mahar Ali. So she has inserted social science
Yes.
because she is senior to you in service.
No.
But Dice Code does not reflect that. She
That's that. And in Dice Code, my lord, this is important. In Dice Code, she claims to be an Assamese teacher.
Assamese, that is language teacher.
She is shifting her stand every now and then.
And if she sticks to language,
English.
In 45, she is English teacher and social.
understood. Social, and if she sticks as a language teacher, then she will not have a march over Mahar Ali. Mahar Ali is much senior. Serial number 2,
Yeah.
1995.
Yes.
So that she has put in social science
Okay.
so that she can be provincialized.
So her intention is not bona fide. First thing, because earlier she herself claims an Assamese language teacher. Then when she saw that morally is more senior, then he shifted her stand and becomes
Both
English
teachers,
teacher.
English as well as social
As
science.
well as social science teacher. But I am always first appointment, everybody is as assistant teacher, but I am always social science teacher. No
Where
way.
is the document to show that you are social science?
These are the document.
Paper?
Dice Code.
No, Dice Code is later.
Dice Code is later.
Initial appointment.
Appointment letter, assistant teacher, you show your appointment letter. So there is no appointment letter.
When was this Dice Code prepared?
Dice Code first time in 2009, madam.
Okay.
2009, 9 and 10, that is the first.
No, 2007.
It is 32.
2007. You come to page 41 down below. In 2007 only you were recognized as social science. Her language was Assamese.
Yes.
Page 41 down below.
Yes, yes, yes.
Printed on 2007.
Yes, 2017.
7.
No, that is.
Printed.
Yes.
Printed, just printed for school, so and so. Page number 9, printed on 1 January 2007.
Yes.
Last line after the box.
Yes. Yes.
After the box.
Yes, I have seen, madam. There is printed on 1/1/2007.
7.
So that's cut of 2007. But normally in the 2011 and 2009 is taken for consideration. 2017. So here also Lordship would see, she is claiming Assamese teacher. On earlier occasion, she is headmaster. Then she became Assamese language teacher. Then she became English as well as social science teacher. So
why is this discrepancy? If this is printed in 2007, why year of 2017-18 is written? I think it should be 17.
Yes.
My lord.
17, 18, that is also in the top, right
Top,
side.
17-18. So below it cannot be 2007, I think.
That does not tally actually.
Cannot be. You cannot know a data of 2017-18, 10 years earlier.
Actually, the data is of 2009.
17. 8 to 7.
And it is prepared in 2017-18. So, my lord, why only first prayer is this? Everybody is first appointed as assistant teacher.
Correct.
Thereafter, according to their subject, they are newly named. So in that view, I was earlier appointed assistant teacher, thereafter social science everywhere. And she is the headmistress. Then she becomes Assamese language teacher. Then she becomes English as well as social science teacher. And as she has misused her power because she is the headmistress, so she takes up the pen and whatever beneficial for her, she takes. And she is the ultimate beneficiary of all these things. And ultimately, she got the post. My submission is this: I am not against her post, but as I am entitled to get the post, so in exchange of my own post, I cannot sacrifice to her interest. So in that view, the provincial order of February 2021 passed in favor of Alaya Khanam should be set aside, and the present petitioner should be appointed in her place. However, if there is any scope to take her back in any other post, I have no objection. That is my humble prayer.
Mr. Bora?
Here, my lord, first of all, for provincialization under the act, my lord, district scrutiny committee has to forward the name of the particular teacher. The name of the petitioner has not been forwarded by the district scrutiny committee.
Just a minute.
One minute, my lord, 1 minute. They have filed affidavit. In affidavit, they say that this scrutiny has not forwarded. So we are before High Court. High Court will say why they have not forwarded. And if forwarded wrongly, High Court will definitely interfere. That is our case.
You have filed an affidavit?
My lord.
When?
On 8th of May, my lord. 10th of May, my lord.
10th of May?
10th of May, 2023, my lord. Here we have
Just a minute.
Here, my lord, we have in para 6, my lord, we have specifically stated that, my lord, as per section 13B of the act, my lord, name of the person teachers have to be forwarded by the district scrutiny committee. My lord, name of the petitioner is
Paragraph?
paragraph 6, my lord. Of our affidavit. After verification by the district scrutiny committee, my lord.
13B.
My lord.
Yes.
Here, my lord, district scrutiny committee has forwarded only 3 names, my lord. Where name of the petitioner is not there, my lord. Thereafter, my lord, state level committee has recommended, my lord, only 2 names, my lord. Accordingly, my lord, only, my lord, out of 3, my lord, only 2 have been appointed, my lord, as a tutor, my lord.
Okay. Okay.
As per the act, my lord, first of all, my lord, any person, any teacher's name has to be forwarded by the district scrutiny committee. Thereafter, my lord, state level committee has to recommend that name.
Mm.
Then can be, my lord, a teacher can be appointed as a tutor or teacher, my lord.
Mm.
Well, here, my lord, petitioner has shown the, my lord, dice data at page 41, my lord.
Correct.
Here, kindly see this dice data of 2017-18, my lord. Here, respondent number has been shown as main subject of Assamese.
41.
My lord, page 41. Respondent Alia Khanum, main subject of Assamese. And my
Assamese,
lord,
right?
my lord, left side teacher 1, my lord.
Yes, yes.
And my lord, kindly see page 32. This is also a dice data of 2019,
The page 41 is of 1718.
17-18. My lord. This is a dice data of 2019. Here,
Page
my lord,
40.
page 41. My lord.
The next one.
Next, page 32, my lord.
Thirty-two.
My lord.
Yes.
This is a dice data of 2019. Here, my lord, a respondent number 9 has been taught, my lord, main subject taught 1, my lord, all subject.
One is
All subject, my lord.
head teacher.
That is a, my lord, main subject taught, my lord. Here, kindly see, my lord, classes taught, main subject taught, my lord.
10.
My lord, this is, my lord, column number 1, 2, 3, 4, 5, 6, 7, 8, 9.
All subject. No, all subjects are
In the
there.
top of
But then
top, man, Alia Khatun,
Yes.
thereafter sex, date of birth, caste, category, year of joining, highest qualification, classes taught, main subject of life.
A1.
One is all subject, man.
Okay. Okay.
And my lord,
All right,
petition,
just a minute. Just a Okay.
petitioner is for my lord, environmental fence.
Petitioner is 4.
environmental studies.
Yes.
Here, my lord, first of all, my lord, any person and name of any teacher have to forwarded by the district school unit. Then thereafter, my lord, state level committee has to recommend it accordingly. My lord, any person will be appointed as a teacher. This is the first criteria as per Act. My lord. Here, my lord, name of the petitioner has not been changed. Another thing is that, my lord, there is a appeal provision under section 14.
Section?
That can be availed by the petition. First
Section
of all,
14.
Section 14 of the Act, my lord. Petitioner can avail that, my lord. First of all, here there is a provision, my lord. He has not filed any appeal probably. Let him file an appeal, my lord. After deciding that, my lord, he may be approached this honorable petition. Another thing is that, my lord, petitioner has stated that, my lord, his name has been not forwarded by the district level committee. My lord, district level committee has forwarded after verification all the documents provided by the school and the block elementary education and district elementary education. That is why, my lord, probably he is not eligible for the post of teacher or tutor, my lord.
Mr. Bora, it's okay, your submission, appeal is there. We may also think of remanding, but he has raised a basic question.
Well.
How the name of the response number was preferred by overlooking the claim of the petitioner.
Well.
And in support of that claim, certain documents have been placed on record.
Well.
No doubt the district committee might have scrutinized the documents,
Well.
but he is trying to make out a case that scrutiny or examination does not appear to be correct. There are documents to show as per the petitioner, that even the substantive appointment
my lord,
of the respondent number 9 was not social science.
my lord,
It was a language teacher.
my,
Initially Assamese, it turned to be English later on.
my lord,
And in her own, we may not accept the first submission that head teacher is not entitled for provincialization.
my lord,
We have to go by the substantive post. Head teacher is only an administrative function.
my lord,
Substantive post, as per the petitioner, respondent number 9 initially claimed to be of Assamese, then it records that it is English, and in the final order,
my lord,
he becomes a teacher of both language as well as social science.
my lord,
Whereas all along, it is the case of the petitioner that she is working as a social science.
Right.
So if you go subject-wise, it is the petitioner who is the only candidate
my lord,
who may be entitled for provincialization.
my lord,
And so far as language is concerned,
my lord,
we find from the records that there is another person who is much senior to both the
my
parties.
lord,
That his case is that only to overcome that hurdle,
my,
the petitioner has conveniently inserted
Well.
social science to be one of her subjects because he is otherwise senior to the petitioner in the school.
my lord,
How do you react to this
my
subject?
lord, my lord,
This is
very,
your craft, isn't it? Mr. Mahmood,
My lord.
this is the
This is
craft
my
of the
case.
subject.
Substantive post I am holding social science.
Yes.
He is
initial,
headmistress.
very initial appointment of the every teacher of a.
I think Mr. Sheikh will have a lot of explanation. I think you're also for the school, isn't it?
My lord.
You're also for the school.
Yes.
Yes, we'll come to you.
My lord,
Your submission will be very important. Yes.
very appointment of the petitioner, my lord, every teacher in a provincial venture school, my lord, as a assistant teacher. They have not been appointed as assigned for a particular
Correct,
subject,
correct.
my lord. Thereafter, my lord, diets that have been prepared,
Hmm.
there's, as per my limited knowledge, there are so many discrepancies, my lord. Some teachers has been chosen as socialist, thereafter again, my lord, Assamese.
Hmm.
My lord, and another thing is that, my lord, there is no post of headmaster in LP school. My lord. This is, my lord, this is on the seniority basis, any person has been assigned to do the administrative work, my lord. That is why a headmaster post is not
So
there.
as we have already made ourselves clear that we are not too much impressed about the headmaster.
My lord,
We are on the substantive post
my lord,
which the respondent number 9 is holding vis-a-vis the substantive post of the petition.
my lord.
That is the only consideration.
In para 9 of their affidavit, they have also clarified. Government has clarified there is the para 9 regarding headmaster.
Here, my lord, senior is respondent number 9. My lord. He is senior to the petitioner, my lord. My lord, here, my lord, initially, my lord, all the headmasters, my lord, from Venture School, my lord, headmaster have to teach all the subjects. That is why, my lord, here she has been chosen as, she taught as all subjects, my lord. And my lord, as per act, social science teachers is required, my lord. But my lord, name of that, my lord, teacher have to forward it by the district scrutiny committee after finding him eligible for the post. And my lord, for my lord, teachers under my lord excessive post, my lord, who are, this can be done only after my lord in the base school only. In the provincial school, my lord, the school has not been provincialized, only post has been provincialized. My lord, these teachers, the additional teachers can be appointed in the base school only on the base of the students requirement. Additional teachers can be appointed.
We have not understood this.
My lord, here, my lord,
What is the name of the school? Dakshin Kumalipura ME Madrasa.
that is the provincialized school. My lord, here, my lord, this respondent number has been respondent 9 has been accommodated in the my lord base school.
What is the base school?
The school can not be kept. Dakshin Kumalipura school is the provincialized school or venture school. My lord, here, my lord, respondent number 9 has been accommodated in the base school. अपना appointment letter
But we have understood.
Bania,
School-
Baniapara,
That means the school, the provincialization is not vis-a-vis the school in question.
my lord,
It is only for the services of the teachers.
my lord,
So while provincial is in their service,
my lord,
since Dakshin Kumalipura continues to be in the venture state,
my lord,
they have been put into service in some other school.
basis,
That's right.
my lord,
What is the name of the school? Will
Baniapara.
Baniapara.
Posim Baniapara LP School, my lord.
LP school.
My lord,
Same district.
my lord. Borpeta, 11506 number Posim Baniapara LP School.
Yes.
That's all.
May it please your lordship. My lord, your lordship, after hearing my learned friend and the government side one, almost clear regarding this thing. Now your lordship, just trying to please before your lordship. Section 311, my lord.
3111.
3.
3111.
Yes, my lord. In this book, my lord, page
Yes.
111.
Triple one. Yes.
Yes, my lord. Now your lordship, in case of Vansar Upper Primary School, in case of Vansar Upper Primary School, there shall be minimum 3 teachers or tutors. At least one teacher is for social science and mathematics, social studies and language. Now your lordship, there is no dispute regarding science, mathematics. There is no dispute regarding language also. Now dispute is regarding social studies. Now your lordship, this is my submission, my lord, your lordship made correctly. Social science, there should be a social science teacher, the upper primary school, to take teachers on mathematics, on social science, on language. Language is no problem, mathematics is no problem. The social studies, a teacher is to be taken. Your lordship will consider that your lordship already pointed out that the post of headmaster cannot be treated as social science teacher. That cannot be. That is already overruled by the honorable court. Now, question is one social science teacher is to be there.
Correct.
Now, who will be the social science teacher? There must be some qualified social science teacher. I am a graduate, my lord. I am a graduate, senior by 1 year, 1 year, some months, my lord.
Yes.
1 year, 15 days, 10 months, 15 days. Senior to the writ petitioner. My lord, my humble submission before your lordship. In the last document, it is shown that I taught English and social science. And my learned friend submitted that sometimes I taught all subjects. Because a headmaster, my lord, I am a graduate, a headmaster holding the post of headmaster, sometimes language, sometimes history. In this way, it is gone. It is goes, my lord. It is not confined. Headmaster is not confined.
What is your categorical case?
My lord,
What did you teach?
my lord,
What is your case? What did you teach?
my lord. Initially, from record, I am to see, my lord, that
No, no, it's not a question of record.
my lord,
You're before us.
my lord.
We want to know from you, what did you teach?
I teach social studies, my lord.
Okay. Have you stated in your affidavit?
Yes, my lord. In my affidavit, I have specifically said that social studies, sometimes English. Social studies I taught in the school. So, my lord, my another submission before your lordship, one social science teacher is to be taken. Now your lordship will consider whether a graduate teacher, I am a graduate teacher,
Correct.
whether I am qualified to teach social studies or not in upper primary.
No,
For
no,
provincialization-
that question perhaps will not go.
My lord,
Your qualification is not the question which we have to answer.
my lord.
I am also qualified.
My lord, now your lordship,
The assignment, we are on the assignment.
my lord,
Even a maths teacher can say, I can teach Assamese language
Well.
for ME. I can teach English language,
my lord,
but that is not our
my
lookout.
lord,
Our lookout is actually what did you teach?
my lord.
If it is recognized that you taught all the subjects which included social science, matter would be different. But we perhaps will have difficulty in accepting a submission that since I'm a graduate, I can also teach social science.
Well.
Can also and I have been teaching will be different. We want to know who amongst you
My lord,
were teaching, imparting the or teaching, having the subject of social science, social studies, and imparting knowledge, education in the subject
English.
of social studies in the school. That is our only lookout.
Yes, my lord. My stand is this, my lord, I taught social studies. And another thing your lordship will consider, last particulars, which has been submitted,
Hmm.
that is considered by the district scrutiny committee. And thereafter, my lord, my name has been recommended.
Why is
Now
why is there inconsistencies in the record so far your service is concerned?
My lord, yes.
He is
Last-
trying to
last-
highlight that from time to time,
Yes.
the subjects which you are teaching, there is a difference.
My lord,
Initially, it was English,
Hmm.
then it became something else, and
language.
finally,
Hmm.
language as well as social studies.
Last particulars is social studies.
So the two social studies and language.
Yes. Now my humble submission before your lordship is this. Your lordship now go to the prayer of my learned friend. That is at page 13,
1-3.
1-3.
Yes.
So
We would also like to know from your affidavit opposition, where have you stated categorically that you taught social studies?
yes,
Kindly ask your junior to have that
my lord.
paragraph.
I-
In the
I-
meantime, you can read your read the prayer. You want
Yes,
to
my lord. Page 13.
1-3, yes.
First prayer is set aside recommendation of BSc. So, my lord, here my submission is the to set aside recommendation of BSc. That BSc recommendation, your lordship will consider. BSc recommendation is not placed in the writ petition. To set aside BSc recommendation, that must be in the petition. Without annexing BSc recommendation, writ petitioner wants to set aside that recommendation, which is not possible on the part of the Honorable High Court. To set aside notification set aside notification of provincialization. That notification as a whole is not before your lordship.
No, so far it is qualified.
Well,
So far it relates to the petitioner school is concerned.
well,
There's a line.
yes,
Come to the middle of paragraph page 14.
well,
The whole provincialization is not challenged.
Well,
It is only so far as
to set,
petitioner's school is concerned.
to set aside notification of provincialization.
Yes,
Yes. So that notification is there, but that entire thing is not placed before your lordship in the record.
that is there. Why not?
My lord, your
Oh.
lordship.
4-2? 4-2 is not before us.
Yes.
Page
4-2
73, my lord.
4-2 is there, page 73.
District recommendation is page 73 of government's affidavit.
No, even the
Now, under government affidavit, it may come.
Yes, all are parts of record.
data capture. No, even 4-2-21 is it's there at page 46 of the writ petition.
My lord. I am looking on.
46. Isn't it, Mr. Mahmood?
Yes.
46. Your petition, last page. You have also given the list.
Yes,
140
list.
140 is response number 9.
Yes. So far it relates to her case. We are not against entire.
Then I have said,
Yes, my lord, that is 851. To set aside the notification.
yes,
Leaving that, my lord. To set aside the impugn appointment. Appointment order was not on record by my learned friend. Last one is the provincialize the writ petitioner as social science teacher. Well, my humble submission before your lordship, there is a procedure for provincialization. There is a procedure because headmaster is to forward the names of the teachers and thereafter the district scrutiny committee to look into the entire records. Not that district scrutiny committee is confined to the recommendation of the headmaster only. My lord, again I am coming to this, my lord. Here it is specifically written, provided that for the in case of Bhavantar upper primary school, there shall be minimum 3 teachers, so and so, so and so. And this district scrutiny committee has got power to look into the entire things, entire particulars, not only the recommendation of the headmaster. Now question arises, my lord. District scrutiny committee, my lord, done their job on the basis of some particulars, some documents placed before the district scrutiny committee. And district scrutiny committee, after going through the same, it has been done. Now clear is this, my lord, straightforward. Provincialize the writ petitioner as social scientist. He is not recommended by the district scrutiny committee. How? Honorable court directly provincialize the service. It is not proper prayer. My humble comment. How it can be done? It cannot be. Now, my lord, your lordship pointed out to me that where I have stated in my affidavit in opposition that I teach English language.
social science,
So social science, my lord. Yes, my lord.
paragraph.
My lord, I am referring with it. 67. My lord, just I am typing something. My lord. My lord, your lordship will turn to page 68, my lord.
Paragraph?
Paragraph 5. Your Lordship. The deponent states that as per Appendix 1 of the writ petitioner was shown as assistant teacher teaching social science, art, education. Appendix 1 is their document, my lord. I'll show, my lord, Appendix 1. Appendix 1, the writ petitioner was shown as assistant teacher teaching social science, art, education. So, my lord, here also it is shown that she is not confined. The writ petitioner is not confined only to the teaching social science, teaching social science, art, education. And the opponent was shown as
Where is Appendix 1?
Appendix 1. I am going, my lord. The deponent was shown as teaching English and social science. Now, your lordship, Appendix 1 at page 45. Page 45. Your lordship, Alia Khanam, deponent, my lord. English, social science. It is their document, my lord. Zorina Khatun, assistant teacher, social science, art, education. They placed this document before your lordship for consideration.
No. This document, is author is you.
My lord.
You are the author. They have not relied upon this.
My lord,
They are
I'm-
trying to develop a
Your-
case based on
I
this.
humbly submit before your lordship. I humbly submit before your lordship that his service is not provincialized. Till then, my lord, I was the headmistress. I was recognized. I am running the administration of the school. No other question raised. Now, my lord, if everything is accepted,
But you have not shown that statement in your affidavit.
my lord,
Where have you stated that you say that from the format, it is clear that you are teaching social science.
my lord.
You have to make a statement that I am teaching social science. Where is it?
Yes, my lord, that is my statement, my lord.
That is not your statement.
My lord.
You have,
Let me see, my lord.
you took us to page 68,
68.
paragraph 5. It goes to show that both, as if you are inferring
My lord.
only from a document. If you are
Yes, ma'am.
teaching, you have to say directly that I am teaching and verify it's true to your knowledge. Your statement cannot be
Well,
based upon a document that you are teaching or not.
Just I am coming. Well, I am taking some time, your lordship.
You come to page 70. 70,
Yes,
paragraph 8.
paragraph 8.
Read paragraph 8. You are not prepared, Mr. Mistake. Come to the fifth line from the bottom.
Both the deponent and writ petitioners were teaching social science in the school, but as the deponent was senior to writ petitioner.
You
I'm
come to the next page,
I'm sorry, my lord.
page 71,
My lord.
10th line from top. The deponent teaching.
The deponent teaching social science and the writ petitioner also teaching social science as the district scrutiny found deponent as senior.
You're not showing us this report of court. How have we verified this paragraph 8? Let us see. Is it true to your knowledge? Yes. True to your knowledge. Okay.
Yes, sir.
Okay.
So, my lord, now the question, my lord. Here, my service was provincialized on the basis of district scrutiny committee, my lord, recommendation. And regarding social science, my lord, my humble submission before your lordship, as I refer to,
Mr. Mahmood, have you filed reply to this?
yes, reply has been filed, my lord.
We'll come
Yes.
to you. We'll come to you. We'd like to have your reply to paragraph
Yes,
8.
my lord.
We'll come to you. Be prepared.
My lord.
Yes.
My lord. Now, your lordship, all the questions said by my lordship, my learned friend, my lord, head petitioner, is to be answered. But whether without proper scrutiny, my lord, without if the district scrutiny committee to sense their recommendation, my lord, they have to gone through these fresh documents placed before it, my lord. Without those documents, my lord, re-scrutiny of the document, and after re-scrutiny also, my lord, district scrutiny committee may keep their stand tact. So, district scrutiny committee is to do something. If your lordship finds that there is some wrong. So, my lord, it is not the case that the straightforward, this honorable court will set aside the recommendation of the district scrutiny committee. That cannot be. Because it's based on some document. And that document is not the creation. That document is not the creation of the district scrutiny committee. District scrutiny committee recommended on the basis of some documents. And those documents were from the initial stage, it is placed before the district scrutiny committee. So district scrutiny committee, it is not the district scrutiny committee did not recommend it on their own. It's based on some document, on some reasons. In a meeting, my lord, on district scrutiny committee meeting held, my lord, entire districts papers are recommended in a meeting and then sent to the director of elementary, the state level. That is the thing, my lord. So state forward, it cannot be done. And
are you submitting that the role of the district scrutiny committee is not a mechanical one?
is not mechanical. It's not
And
mechanical.
it is not.
Cannot be.
It is only not dependent. Only not dependent on
Cannot
the
be.
recommendation of the headmaster. They make an independent exercise.
Listen.
They examine all
has
the
power. It has power in the act itself, my lord. That district scrutiny committee, if not satisfied, they can further look into the document, inquire into.
In fact, in this case, 3 names, out of 3, only 2 have been recognized.
My lord. Who
They
has
have the power even to say no.
Because possibly there was nothing, there was no teacher eligible found. And it is also from the record, it will reveal, my lord, district, if originally the original record of the district scrutiny committee is placed before your lordship will find that there is clause 6. In clause 6, it is said that teachers who are eligible for provincialization. And 7, teachers, name of teachers who are not eligible. So my learned friend comes under not eligible category. And now she is to be made eligible. Who will make it? It is by the district scrutiny committee. First is 2. They are to rehaul this everything. Thereafter only he can come to the zone of consideration. So that original documents will show that exactly there is eligible category and not eligible category. That's my humble submission. And secondly, my lord, I want to submit before your lordship statutory provision is there, section 14, my learned friend referred to.
For appeal.
Yes, my lord. And many grievances raised, my lord, which is not possible at this stage, my lord, by your lordship to answer. So, my lord, coordinate bench of this Honorable High Court, my lord, decided the matter, considered section 14 as well as section 19(2) of 17 Act 1. I'm telling you. What has been considered by the coordinate bench, my lord? The case is totally covered by this facts and circumstances.
But here, even if we follow this,
My lord,
in the third page, the last page rather, page number 5,
page number 5.
well, the first paragraph is that the writ petition was held to be not maintainable. Only under those circumstances, the liberty was granted to prefer an appeal.
Yes, my lord.
We read the first paragraph of page 5, as noted above,
Page 5,
last page,
my lord.
as noted above.
As noted above, the
Full in
in
question
question is Vansar Educational Institution.
and matter pertaining to
Matter pertains to provincialization of service of petitioner. As such, this writ petition is not maintainable.
under those circumstances. Here, the question of maintainability has not come.
No, my lord. Here your lordship will please to read the whole.
No, you have read,
Yes,
no,
sir.
you have made a submission. We may not we may not be required to go to the decision.
Is not maintainable. Why
No,
it is
no, no,
said?
you have said that.
No, my lord, facts is same. I humbly submit before your lordship. I have gone through the,
Are you raising the question of maintainability?
in my affidavit in opposition.
No, in this proceeding, you have not raised the question of maintainability.
No, my lord, question of maintainability, I have not raised in my affidavit in opposition. But my humble submission before your lordship, here is where there is clear alternative remedy.
That part
My
will
lord,
consider.
yes,
That part will
clear alternative remedy, and your lordship would be pleased to see at this point that not maintainable, my lord. This order has come on 2/2/2021. 2021, my lord, and my reply is affidavit in opposition is submitted earlier.
No, but see, the entire consideration in this case,
My lord,
after discussing.
my lord, that regarding maintainability, my lord, I am skipping this point, my lord. But I am submitting before your
You are
lordship
entitled to
regarding-
you are entitled to raise the issue of alternative remedy.
my lord, alternative. I'm confining to alternative remedy. Because when alternative remedy is there, not only that, my lord, this honorable court decided that you file first appeal before under section 14. And if you are aggrieved, then you file appeal to the state authority. And then also, if you are aggrieved, then under 19(2), you apply to the education tribunal. So, my lord, there are 3 stages, not that only one stage. So, alternative remedy is to be exhausted. And your lordship, many questions raised by my learned friend. This is not a straightforward case. Many questions raised. And my learned friend also from record shown that sometimes this language teacher, sometimes English and social studies, and last is social studies, that has been considered by the district scrutiny. So, my lord, on this point of alternative remedy also, I will place my case. And your lordship.
Are you relying on any decision of?
My lord.
Are you relying on any decision regarding alternative remedy submission?
Alternative remedy decision, my lord, I have. There is a sufficient alternative remedy decision, my lord. Recent decision.
Have you got any?
But today I have not. Today I have not. I am sorry, my lord. So, my lord, actually, to be frank, my lord, it is in my mind that when coordinate was decided,
No, we could have very well, but
sometimes,
that was on a different, different ground altogether.
Hello.
The learned
but
court
in that case also,
came
my
to a
lord,
conclusion that it was not
point-
maintainable.
point
Then
of
said that you can approach 14. It has
alternative,
not been held that since 14 is there, it is not maintainable. That is not defined.
not it, that is. not
But
correct.
that is your case, that the
I
14
cannot,
is there.
I cannot go to that because maintainability is not raised. But regarding alternative remedy, it remains my. So, my lord, what was in my mind, my lord, is just that there is alternative remedy decision, possibility that will be,
No, there are many
said that
decisions, as you have rightly said.
if necessary, my lord, I will put it.
We are not,
I will, my lord.
no, we are not adjourning, we are closing this. We are passing final order.
My lord. And that, your lordship, as your lordship aware of, there are sufficient decisions regarding this.
We are not aware unless you show.
Even at two, my lord, I can place.
It's okay.
At two,
It's okay. It's okay. No,
I'll try to place before.
doesn't matter, not we need.
So, in a nutshell, my lord, this is the case. Your lordship. And my learned friend filed reply. On reply, let him come. My lord, if your lordship can pose any question to me, my lord, then I can try to answer. More.
We have already posed the questions.
My lord.
You have answered.
Yes, my lord.
We have seen your paragraphs.
My lord, my lord, my lord. I'm grateful to your lordship that I am not fully prepared. What your
My lord,
Doesn't matter, you are a senior person.
my learned
Much of
friend
it.
has raised one question, alternative remedy. I have so many citations. I will submit just now.
Two basic questions. First, alternative remedy, of course, you'll have to answer.
Yes.
Well, first question which has come to our court, to the mind of the court, is that you have raised certain questions which may have a lot of substance, but those questions ultimately are questions of fact. We are not a court of fact. We will go by whatever materials are before us, and even if we accept whatever you have submitted, at best, it can be disputed questions of fact.
My lord,
Whether it will be proper for you
I am
to have
saying,
your matter adjudicated here, or you go to the appellate court, appellate authority, which will review everything.
my lord, I am submitting. Alternative remedy, if the questions are, lordship is aware about that. In many cases, I have submitted citations. If the questions are not so critical, and if everything can be settled on the basis of the records available before the honorable court, no question of alternative remedy arise, no person should be thrown out to cases after cases. So that is not the law. Here my learned friend has said something, this is student.
First, let us see your reply to paragraph 8.
Yes. That may be seen page 80, ma'am.
80.
80.
Yes.
Paragraph 5.
Paragraph 5.
That with regard to the statement made in paras 8, 9, and 10 of the affidavit in opposition, the deponent begs to state that as per section 3(1)(11) of Assam Education Provision of Services of Teachers and Reorganization of Education Institution Act 2017, it is provided that there shall be minimum 3 teachers, tutors, at least 1 teacher each for science and mathematics, social studies, and language. In that view, 2 assistant teachers are provided in the Act of 2017, out of which 1 teacher is social science teacher, and admittedly the deponent had been working in that post. The administrator, for her own interest, cannot change the provisions of law, citing that the deponent is the junior amongst other teachers. In the Act, there is no mention of junior or senior teacher. Rather, the cadre of the post is mentioned as assistant teacher. On the other hand, there is remedy for the respondent number 9 as provided in the schedule norms and standard for a school in 1B2 incorporated in the Rights of Children to Free and Compulsory Education Act 2009, wherein it is provided that there would be 1 teacher for every 35 children, and in provision 1B3, it is further provided if the admission of children is above 100, there would be a full-time teacher.
There is no denial, Mr. Mahmood.
So there is no denial. So we have clearly stated that for her own interest, she cannot.
We have not denied. You have not even said that the statement made by her that she is the teacher of social science is an incorrect statement. You have not even said.
No, it is the headmistress for her own interest cannot change the provisions of law.
That is
So
not a
that is
denial.
there.
That is not a denial.
Thereafter, my lord, there, it is there.
So,
Is there, kindly see last question.
yes, we have
Last,
read this.
last
read this.
question. The respondent number 9 expresses that since the day of establishment of the madrasa, there were no children admitted above 100 till then.
That's a different point.
Thereafter it is coming. Under such circumstances, service of the respondent number 9 will never be provincialized as teacher or tutor. I am not written, but now to fit her in a suitable position, she has shown her both as English and social science teacher, whereby created the question of seniority between the respondent number 9 and the deponent, and succeeded herself to be provincialized as a social science teacher of the madrasa in connivance with the district elementary education officer Borpeta. As such, the appointment letter dated so-and-so issued in favor of respondent number 9 is illegal and liable to be set aside. So, my lord, this was done. Actually, my lord, my learned friend is repeatedly saying that district scrutiny committee recommended her name. Now, district scrutiny recommends the name of those persons who are forwarded by the headmaster. I have no access with the record. So headmaster prepares
No,
the.
here a question will arise. Here, in fact, in the present case itself, where 3 names were being recommended by the headmistress,
Yes.
only 2 were recommended, 2 were accepted.
Two are accepted.
So it is not a case that it's a mechanical acceptance of whatever the headmaster says. District Scrutiny Committee is a statutory authority under the Act of 14. It exercises its own powers.
No, it
We
has
cannot say-
exercised its
you
own
were
power.
correct in saying that the District Scrutiny Committee had committed error. That's a different submission, but this submission will be difficult to accept that whatever the headmistress or headmaster.
No, it would have
recommends-
mentioned with the help of education officer has in connivance. So lordship will take the spirit of the sentence.
Connivance is a very serious kind of an allegation.
It is serious allegation because he is a headmaster as well as Assamese teacher as well as
Have
English
you made
teacher.
the district elementary education officer a party by
Yes,
name?
he is a party,
Party by name.
not by name, I suppose.
Connivance is a
No.
allegation on.
Some other things I am bringing. So far this seniority, it does not come. Cadre seniority is the main thing. So in social science, there is no 2 teachers. If there were 2 or 3 teachers, then the cadre seniority would have come. So this is not the case. Best school, I will also forward to the best school. If my post is provincialized as tutor, I will also go from Kumulipara to.
Mr. Mahmood, we are not going to the other aspects of the matter. There is one principal issue which you have raised, that you are the only teacher in social science
Yes.
and she was teaching other languages,
Other language.
and only to get benefit of the
Now,
provincialization.
Again, Lordship, kindly for a
Only
moment, page
concentrate on
32. Page 32 kindly come for a moment.
32.
Yes, 32. Here, Lordship will see 4. Top 4 is there. Now, what is 4? It is mentioned in bottom.
Yes, we have seen.
All
subjects,
subjects, languages, mathematics, environmental science, sports, music, science teacher.
No, one is all subject. One, all
No.
subject 1.
Hmm.
Under serial number 4,
One
One
is
is all
the main subject.
all subject.
Main subjects or
Not-
main
not
subjects.
main subject.
Main subjects taught, this is.
You come to the top 1, above 1, there is a super thing, it's
Also.
written as 4.
Yes.
And if you come to the footnote, 4, number 1 is all subjects, number 1, languages, number 2, mathematics 3, and here, so far as the respondent number 9 is
Environmental
there, it's
science,
1.
environmental science means social study, man. Now it is.
Understood. But
Yes.
as far as R9 is concerned, it is 1. All subjects,
It is
all subjects.
all subjects. Now regarding all subject, I am clarifying the matter, my lord. From one of my personal experience, I am giving a little example. I was a teacher at Havli High School, assistant teacher at Havli High School. Many times some teachers did not come. So headmaster was our headmaster T. Goswami. He said, Mr. Mahmood, you go to that class and teach this and that subject. So that is not my substantive post. My substantive post is assistant teacher. But as the teacher on that day, particular day, did not come, so I was asked by the headmaster, you go there and teach. So substantive post should be taken. Her substantive post can never be accepted as social science teacher because she is shifting her stand every now and then. And she is otherwise doing hide and seek policy. I will say in other words, so only to suit her purposes. She is the only, for doing all this, she is the ultimate beneficiary. Now, on the ground of these factual points, I think it is not only factual, it is factual as well as legal points also. Because legal points postulates 3 types of tutors, and 3 types of tutors I will get the preference. I will get the preference. She will get preference if there is more than 100 students. So how she now, Lordship, District Scrutiny Committee is not a mechanical exercise in power. In other words, that is one aspect of the case. But if I say it has exercise power mechanically, because it has never seen the Dice Code of 2017, where I am social science teacher, and she is headmistress. So, District Scrutiny Committee, though not mechanical, but in this case, mechanically they applied their mind. They did not say that you are claiming a social science teacher, but in 2017, her name is there. So they did not call all these records before sending it to the state level committee. So post held here in 2017, my lord, it is clearly mentioned as page 45, clearly mentioned. Even 2000 up to 2017, everything is okay. Page 45, kindly see. Alaya Khanam, headmistress. And it is 5/6/2017. And it is prepared by Alaya Khanam. So since 2017, she is all along headmistress. Sometimes.
Here, if you are relying on this document,
Yes.
post-held headmistress, subject taught English and social science.
English and social science, there
You cannot take advantage of one part of this document and which the other part is.
No, there is another Assamese teacher. Earlier she was Assamese. A person may teach many subjects, but what is the substantive post? Our rotation, this Honorable High Court of several judges are taking several matters. Rotations are there. So it cannot be said that that particular judge will take these matters. So it is rotation wise, but substantial post is, my lord.
I think your example is not fitting here.
May not be, my lord. Then I would do this.
We don't have the discretion to say that we'll take this matter. If the roster.
Then but even then, my lord, every judge have every power to take every cases. But substantive post is one judge, one is Chief Justice. So that is to be taken. However, if it is not befitting that I am doing that.
The expression is not befitting, it's not fitting.
Well, I would do that.
Okay, we'll conclude.
So, my lord, my submission is this. Technicality should not take the field of mandamus. Technical point may be there, but substantive justice should be provided. Substantive justice, that is, if there is no law even then substantive post, substantive justice should be provided.
Something has been shown which is against you. Have a look. And unfortunately or fortunately, you were the counsel before the appellate court. Tajuddin,
Tajuddin Ahmed.
on the point of availability of an appeal.
Availability of alternative very that is controversial judgments are there. My Lord Justice Pathak normally sends to the tribunal and some judges say to the state
But,
disciplinary committee.
The
And here it was perhaps to tribunal.
Writ appellate court
Yes.
is binding upon us.
Directed appellants file may appeal before the education tribunal, at least before the tribunal. It is, and I.
Okay, we'll pass the order.
Hearing will continue what?
No,
It is concluded.
concluded, no? We are going to pass the judgment.
Obliged.
5 minutes. The benefit of provincialization of service under the So Act of 2017 of the petitioner vis-a-vis the respondent number 9 is the issue which arises for determination in the present petition filed under Article 226 of the Constitution of India. Full stop. The petitioner has put to challenge the process by which the services of the respondent number 9 has been provincialized as tutor and has made a further claim that it is the petitioner who should have been given the benefit of such provincialization. Full stop. The school in question where the contesting parties were serving is the Dakshin Kumulipara Ami Madrasa in the district of Borpet. Have a seat, please. Sarah. I have heard Sri M. U. Mahmood, learned counsel for the petitioner, whereas the department is represented by Sri P. K. Bora. Full stop. The private respondents number 7, 8, and 9 are represented by Sri M. A. Sheikh. Full stop. Both the official respondents as well as the private respondents have filed their respective affidavit in opposition. Full stop. Para. The case projected by the petitioner is that both the petitioner and the respondent number 9 were serving in the school for the resurrection Kumulipara, herein after the school. Full stop. In pursuance to the Act of 2017, steps were taken for provincializing the services of the teachers as tutors. Either provincial as a service of teachers or tutors. Full stop. The relevant provision of the Act is reproduced here for the sake of convenience. Section 3, 1, 11. Para. The genesis of the challenge, as observed above, is that while the petitioner was an assistant teacher in the subject of social studies, instead of provincializing her service, the services of the respondent number 9 has been provincialized by treating the state respondent number 9 as a teacher of social studies. Full stop. The petitioner has relied upon a number of documents to demonstrate that the respondent number 9 was the headmistress of the school and was not a subject teacher, was not a teacher teaching social studies, and therefore the impugned action giving her the benefit is liable to be interfered with. Full stop. It is further submitted that though the respondent number 9 appears to be senior to the petitioner from the date of joining the school, such seniority shall not be a relevant factor, and it is the mandate of the rules which will govern, as per which there should be 3 teachers, public tutors for the subject of number 1, science and math, number 2, social studies, and number 3, languages. Full stop. It is submitted that since the respondent number 9 was not a teacher in the subject of social studies, her provincialization could not have been made by considering her to be a teacher teaching the same subject. Full stop. Para. The Mahmood has referred to the order dated 15/2/2006, whereby the petitioner was appointed as an assistant teacher of the school, which was, without any dispute, a provincialized school. Full stop. References has been made to the school information schedule, which is a part of the data collection format and annex data collection format under the District Information System of Education, put in bracket DISD. Full stop. it is pointed out that in the list of teachers, comma, the respondent number 1, the respondent number 9 has been stated to be a head teacher, whereas the petitioner has been shown to be a teacher, full stop. It is submitted that the petitioner is all along teaching the subject of social studies, full stop. Reference has also been made to the data capture format of 2017, which has been annexed as Annexure 8, full stop. In the list of teachers and instructors, comma, so far as the respondent number 9 is concerned, comma, she has been depicted as a head teacher, while the petitioner has been shown to be a teacher of social science, social studies. Full stop. Sri Mahmood, Sri Mahmood has also referred to the application for provincialization of services of teacher, public tutor in upper primary school, which has been annexed as Annexure 9, full stop. In the state application, which has been made and forwarded by the respondent number 9, comma, an appendix is there in which the respondent number 9 has described respondent number 9, while describing herself to be the headmaster, has also stated that she teaches English and social science. Full stop. The list, however, also contains the name of the petitioner as assistant teacher in the subject of social science and art education. Full stop. It is the contention of the petitioner that the respondent number 9 was never a teacher of social studies, and at the same time, comma, there is no dispute to the fact that the petitioner was an assistant teacher in the subject of social studies. Full stop. It is the case of the petitioner that in spite of the aforesaid facts and circumstances, comma, by the impugned notification dated 4/2/2021 comma, the department had provincialized, had published a list of candidates containing names of 3309 persons as tutors whose services were provincialized. Full stop. In the said list, comma, the name of the respondent number 9 has been reflected against serial number 140, whereas the petitioner's name did not figure. Full stop. It is submitted that the state provincialization of the respondent number 9 being in conflict with the statute, comma, the same is liable to be interfered with. Full stop. Para. Par contra, comma, Sri P.K. Bora, the learned standing council, elementary education department, has submitted that affidavit in opposition has been filed on 10/5/2023. Full stop. He submits that the exercise of provincialization goes involves various steps and is not dependent and is not solely dependent on the recommendation of the headmaster of the school in question. Full stop. By referring to section 13 within bracket B of the Act, comma, Sri Bora submits that that such exercise of provincialization is first scrutinized by the district scrutiny committee and thereafter by the state level scrutiny committee, and it is only thereafter that names for provincialization are finalized and recommended. Full stop. In the instant case, comma, he submits that such exercise has been diligently done and by taking into consideration all the facts and circumstances, comma, the name of the respondent number 9 was recommended. Full stop. Para. By referring to the DIAS data of 2017-18, which has been annexed to the writ petition, comma, the respondent number 9 has been shown to be teaching Assamese as the main subject. Full stop. The DIAS data of 2009/2010 has also been referred to, in which the respondent number 9 has been shown to be teaching all subjects, whereas the petitioner has been shown to be teaching environmental studies. Full stop. The learned standing council has also submitted that the statute in question has an inbuilt mechanism for redressal of grievance in the form of section 14, which provides for preferring an appeal against any recommendation of the district scrutiny committee and the state district scrutiny committee and this remedy has not been availed of. Full stop. The Learned Standing Council further submit that since the response number 9 teaches all the subjects and is senior to the petitioner, comma, there is no error, there is no illegality or irregularity in recommending the name of the response number 9 whose services have been duly provincialized. Full stop. The Learned Standing Council clarifies that it is only the services of the incumbents which are provincialized and not the school. And after giving the benefit of such provincialization, comma, the response number 9 with another candidate has been placed in the 1506 number Postim Boniapara LP School in the district of Borpeta. Full stop. He further submits that the very fact that the services the very fact that it is only in respect of two candidates whose provincialization has been recommended goes on to demonstrate that there is an application of mine as one candidate was not given such benefit. Full stop. There are 3 MA6 Learned Council who has appeared for the private respondent has submitted that section 3 within bracket 1 within bracket small Roman 11 lays down the provision for provincialization of the service, and in this case, comma, such provision has been duly followed. Full stop. He submits that the response number 9 is a graduate, and it is not in dispute that she is senior to the petitioner by more than 10 months. Full stop. By referring to the affidavit in opposition filed by the state by the private respondent dated 30/9/2021, he submits that it is the clear case of the response number 9 that she was that apart from that apart from holding the post of headmistress of the venture school, comma, she was teaching social studies Full stop. In this connection, comma, reference has been made, there has been made to the averment made in paragraph 5 and 8 of the state affidavit in opposition. Full stop. Para. The learned counsel for the private respondents has also referred and has also drawn the attention of this court to the prayer in the writ petition and has submitted that while there is a prayer to set aside the recommendation of the district scrutiny committee as well as the order of provincialization of the respondent number 9, comma, those have not been enacted. And therefore, the challenge is not maintainable. Full stop. He has further submitted that the prayer to provincialize the service of the petitioner cannot be granted by a writ court, as such provincialization involves scrutiny of record and are factual in nature. Factual in nature, and such matters cannot be the subject of adjudication of a writ court. Full stop. It is also submitted that the district scrutiny committee took into consideration all the materials on record and thereafter had made the recommendation. Full stop. Para. The learned council has also endorsed the submission of the department by submitting that section 14 of the Act provides for an appeal, and since questions of fact which are disputed are involved, comma, the proper procedure is to file an appeal, which the petitioner has not done. Full stop. He submits that on the point of availability of an alternative remedy, comma, this petition is itself liable to be dismissed. Full stop. Para. Sri Mahmood no. Sri Mahmood, Sri Sheikh, the learned concept, has also placed before this court an order dated 2/2/21 passed by the court in WPC 354/2021 within bracket Gulzar Hussain versus State of Assam. He submits that in the said case, comma, the petitioner, the party was directed to prefer an appeal. Full stop. Really, PK product, PK product, Sri Bora has placed before this court an order dated 17/8/2022 passed by the Honorable Division Bench of this court in WA 228 of 2022, in which the decision of the learned single judge remanding a matter to the appellate court, to the appellate authority in a dispute of the present nature has not been interfered. Absolutely prohibited. Sri Mahmood, learned counsel for the petitioner, in his rejoinder, has submitted that affidavit in reply has been filed to the affidavit of the to the affidavit in opposition of private respondent, in which the claim of the private respondent has been denied. Also, he further submits that the objections raised are technical in nature and technicalities should not come into the way of delivering substantial justice. The rival submissions made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. Full stop. The case as projected by the petitioner, which has been observed above, is that while she has been teaching social studies in the school, which is one of the subjects mentioned in section 3.1.11, and therefore entitled to be considered for provincialization, comma. The response number 9 was the headmistress. Full stop. এটা উপর লিখি বলে দিচ্ছে আচ্ছা মাহমুদ ইনিশিয়েট লিখি বলে Moderator লিখি it is also submitted that the question of provincialization of the services of the head teacher would come only when the number of students is more than 100, and in the instant case that condition was not fulfilled, and the provincialization of the services of the response number 9 was not as an headmistress but as a subject teacher, as an assistant teacher in the subject of social studies. It উপর থেকে ওটা রাস্তা পেয়েছে সেগুলো এটা দুটো সূত্র he submits no the materials on record would show that the response number 9 was in fact also serving as the head teacher of the school, which is an in-house arrangement in a venture school. Full stop. However, comma, the material placed before this court would also reveal that the said response number 9 was teaching all subjects Full stop. This court has, however, noticed that at different periods, comma, there has been some inconsistencies in the subjects mentioned, but it is the categorical case of the respondent number 9 as would reveal from the averment made in paragraph 8 of the affidavit in opposition that she was teaching social studies. Full stop. Unfortunately, comma, though an affidavit in reply has been filed by the petitioner on 26/11/2021, comma, there is no denial to the said averment. Full stop. This court has also noticed that paragraph 8 of the affidavit in opposition of the respondent number 9 has been properly verified as being true to her knowledge. Full stop. Para. For ready reference, comma, paragraph 8 of the affidavit in opposition and paragraph 5 of the rejoinder affidavit are expected herein below. To me, page 68, paragraph 8, quotation modified, and page 80, paragraph 5. Full stop. Para. Though the petitioner has emphasized that the benefit of provincialization should not have been given to the respondent number 9 and rather should have been given to the petitioner, comma, such contention is not only disputed, but there are materials to show that a different conclusion is also possible to be arrived at. Full stop. The record pertaining to the scrutiny of the cases of the petitioner vis-a-vis that of the respondent number 9, however, has not been placed before this court. Full stop. Under those facts and circumstances, comma, this court is of the opinion that instead of a opinion that since questions of fact which are disputed in nature are involved, coupled with the fact that the statute provides for an appeal, comma, interest of justice should be served if the petitioner is if the petitioner approaches the appellate authority by preferring an appeal as provided under section 14 of the Act. Full stop. This court is also fortified in drawing the said opinion as there are materials placed before this court, including categorical averments made by the respondent number 9, denying the case of the petitioner, and there is also a presumption that the exercise conducted by the district scrutiny committee and the state level scrutiny committee have been done by due care and attention. Full stop. Para. This court So far as the decision placed on record, this court decision placed on record by mistake, so there is no dispute that say, perusal of the state decision would reveal that before passing an order of remand, passing the order of remand, the writ petition was itself held to be not maintainable, and therefore this court is of the opinion that the state decision cannot come to the aid, may not be required to be, may not come to the aid of the respondent. Sarah? So far as the decision relied upon by the department is concerned, within bracket, of Tajuddin Supra, this court is this court has noticed that the Honorable Division Bench has endorsed the view of the learned single judge in remanding the matter to the appellate authority. Even in this case, under the aforesaid practice circumstances, this court has already recorded a finding that interest of justice would be served if the matter is taken up before the appellate authority in accordance with law. Under the aforesaid practice circumstances, this court, while not interfering with the impugned orders, impugned action, has however given, however not interfering, is however of the opinion that a liberty be granted to the petitioner to file an appeal as provided under the Act of 2017. It is needless to state that since this proceeding was pending before this court, the appeal is not liable to be dismissed on the grounds of any delay and is to be adjudicated on merit. While doing so, the appellate authority is required to give the affected parties, both the affected parties, an opportunity of hearing. The appeal may be filed within a period of 2 weeks or 3 weeks. 3 weeks from today, and in the event of filing of the same, the appellate authority may take up the same for consideration and dispose the same expeditious and preferably within a period of 3 months from the date of receipt of such appeal. We'll extend our sitting for some time because second half we may not be able to sit. Not only today, tomorrow, and day after. Hmm?
Appeal is to be filed under section 14.
Obviously,
Yes, Lordship. Obliged.
that is the act which is operating.
Item number 2022. Despite the listed Friday next year.
Item 18
No, we are here. We're extending our sitting
My lord.
by at least 20 minutes.
My lord, item 20.
We are not rising now. We won't be sitting in the second half. So we want to do some cases till we rise. Yes, next. Top of the list. Yes, sir. Today no part one, bench one matters. Only bench two matters.
Lordship has already heard this matter, Lord.
Is it?
Yes, sir. And Lordship, the record was directed to be produced.
B.Ed matter over. B.Ed.
Lordship, with regard to selection and appointment of the post of principal in Malo Ali High Secondary School in Jorhat district.
Yes. You have the record?
My lord, I have received the reconstructed records of the selection of my appointment
the
of the
water
regular principal. Here, my lord, it's contained minutes and a statement of interview and
Now where is the water?
My lord, Mr. S. Botakur is on Lakeside Courtroom 21, my lord.
Less than 215.
Yes, my lord.
Lordship, in this case,
We'll do one thing.
Yes.
We'll take this up for disposal tomorrow.
tomorrow.
First item. Tomorrow you'll be prepared. First item.
Well-
Because this is top of the list. 17 matters, otherwise also this is assigned to this court tomorrow. Today, final disposal may not be possible.
Obligement.
A prayer for adjournment. A prayer for adjournment has been made on behalf of three as Botakur, Senate Council, appearing for the number 6. Put the para. Considering that this matter is listed under the column within inverted comma, top of the list, list again tomorrow. As per stated.
All right.
Now list again tomorrow. But we'll take it up. Upgrade or take it up. Don't try it first item.
My lord, I'm paying for response number 7, my lord.
Not 6,
Not 6.
7. Mr. Sharma?
Lordship, what happened is, in this matter, your lordship, there is no surviving legal representative of the respondent, your lordship. Nobody is there. The whole clan is wiped out, your lordship. Nobody is there. So therefore, order 22 rule 4A and 5 may come into play, your lordship. Order 22 rule 4A, your lordship.
Yes.
May I read, your lordship?
Yes, yes.
Procedure where there is no legal representative.
Correct.
If in any suit, it shall appear to the court that any party who has died during the pendency of the suit has no legal representative, the court may, on the application of any party to the suit, proceed in the absence of a person representing the estate of the deceased person, or may by order appoint the administrator general or an officer of the court or such other person as it thinks fit to represent the estate of the deceased person for the purpose of the suit, and any judgment or order subsequently given or made in the suit shall bind the estate of the deceased person to the same extent as he would have been bound if a personal representative of the deceased person had been a party to the suit.
What about 2, the requirement of notice?
Yeah, before making an order under this rule, the court may require notice to the application for the order to be given to such of the persons having an interest in the estate of the deceased person as it thinks fit. B says, reads your lordship, shall ascertain that the person proposed to be
Should
appointed.
not have any interest.
So-
The
yes,
person
yes,
appointed
your
should
lordship.
not have any interest in
Now-
the property.
Now, if your lordship comes to rule 5, your lordship, where a question arises as to whether any person is or is not a legal representative of a deceased plaintiff or a deceased defendant.
This will not come. This will come into operation only when somebody comes ahead and says, and it is disputed whether he or she is a legal representative. The proper provision is 4A, which you have just relied upon.
Yes.
In that case, there will be a requirement of a notice.
Lordship, may I suggest to Lordship that this matter may be remanded to the trial court to decide as to whether who would be the legal representative. And if your Lordship looks at the Hindu Succession Act.
No, Mr. Dr. Sharma, there is 5 will come into operation when there is a dispute arising. Who will be the legal representative?
Lordship.
In the instant case, you are making a statement that there is no legal error.
Lordship.
So the applicable provision is 4A,
4A.
which would require a notice to be issued,
Lordship.
giving in the general public
Lordship.
regarding the facts and circumstances.
Lordship.
If nobody comes forward,
Lordship.
if somebody comes forward, then we decide whether it's a LR legal representative or not, because you have said there is no legal representative.
Lordship.
He may be an imposter or anybody, he may be a bona fide person. So after notice, if nobody comes forward, court goes ahead with making an appointment. By following 4A, he should be a person having no interest with the property. But for that, you need to issue a notice. And that notice invariably has to be in a local daily. Have you taken instructions from your client for a
Regarding,
paper publication?
no, that has not been taken by me.
Because paper publication, you take instruction, because without instruction, we are not going to pass an order immediately.
Because
This will incur expenses. You take instruction.
but in your Lordship, if your Lordship comes to the Hindu Succession Act, Section 29, failure of heirs, it reads, if an intestate has left no heir qualified to succeed to his or her property in accordance with the provisions of the Act, such property shall devolve on the government. So, therefore, may I suggest that the government may be made a party, your Lordship, so that the matter may proceed. Indian
No,
succession.
first, we are dealing with this case which has arisen from a proceeding which has already come to a culmination. It's the second appeal.
Lordship.
Now, in the appellate case, you say that the respondent has passed away, there is no legal error. Now, we have to first follow 4A. Whether that provision of Hindu Succession Act will be applicable in what case, that will be a different matter. After maybe hearing the appointed person, we may take recourse of Hindu Succession Act. First, you take instructions whether it's not a question of whether, when can we pass the order of paper publication?
Next week, your Lordship.
We give you 10 days time.
That may be fixed, your
Yes,
Lordship.
yes. Dr. R. Sharma, learned counsel for the appellant has submitted that as per information received, the sole opposite party respondent has expired and there is no legal error. He has also referred to the provision of Order 22, Rule 4A, which lays down the procedure in case where there is no legal representative. A perusal of the provision of law would reveal that there would be requirement of a notice of the application, so that any person having any interest in the estate is aware of it. To enable such, however, before passing such an order, this court deems it fit to give an opportunity to the learned counsel to take adequate instructions from his client. Accordingly, list of the 10 days.
The date may be fixed.
Tell us. list, list on,
Candidates.
list on 11th of August.
Obligation.
May please, your lordship. Lordship, there in this case, lordship, the respondent number 1, 2, 3, they are the foreigners, belongs to Bhutan, lordships. And one car came into Assam and an accident.
Car registered at Bhutan.
Bhutan, lordship. And ultimately, lordship, in the year 2012, ultimately, lordship, when case has been filed, and that case,
There was an accident.
accident, lordship.
Somebody died.
Somebody died, lordship.
Where?
In the year, on lordship national highway,
Where?
in the district of Barpeta, lordship. And ultimately, an MSP case has been filed before the Kamruk Metro, lordship. And this case notice has been issued, and insurance company of the Bhutan, lordship, he was appeared and filed his WS at the initial stage. And thereafter, lordship, he did not appear. He in this in her WS, it is categorically stated that this policy is covered within. And ultimately, lordship, this case was filed on. And after filed on, lordship, when petitioners came into knowledge, then is a file and restoration petition. That petition was dismissed on the ground of lordship delay. So lordship, accordingly, lordship, the present petition is here, lordship, and notice has been served, sent, lordship. But till date, lordship, no reply or unserved notice has been come. That's why, lordship, I have made a party, the Union of India, to serve the notice, lordship. And accordingly, lordship, as for the last order, lordship.
Who is the peer? Who is the
Lordship, his name is not showing, lordship. Though, lordship, last 2 occasions, this code has been directed to this registry to show the name, lordship.
Who
But
is the peer? Name.
lordship, I think, lordship, R.K. Chaudhary, lordship, will be R.K. Chaudhary, additional solicitor general.
Has somebody appeared?
No, lordship, they did not appear. But in IA, lordship, their name is reflected, lordship.
IA. You know it. How I hope certain counsel for the petitioner. Not, the causes does not reflect names of the learned counsel the respondent. Hawk, the learned counsel has referred to an order dated 2/1/2023 passed by this court in IA Civil 3834/2020, whereby Union of India was implicated as respondent. Sarah, that the matter will be after on Friday next.
Yes.
By
Lordship, sorry, lordship, I have some problem on Friday.
Monday next.
Yes.
On Monday next. By effect, the name of the RKD Chaudhary, the learned deputy SBI in the court. Let us see once they come.
Yes, Lord. Highly appreciate, lordship.
May please, your lordship. Lordship, as per office note dated 27/23, service is complete, lordship, but LCR has not come.
Lordship, in this case, lordship, another appeal has been filed by the claimant, lordship. That is
For announcement.
enhancement. That is admitted and fixed for hearing. Lordship, in this case, that case, lordship, LCR was checked with their case, lordship.
This court has been apprised that the claimant in this case have also preferred an appeal for enhancement, which has been registered as MSC appeal number
290
290
22.
290/2022. Court of Three, I hope Senate Counsel who appears for the claimant has submitted that in the said April, comma, healthier has been received. Put the para. Since the present appeal has been admitted, comma, that the same bill is still along with MSC number 29022 after a week.
Lordship, in this case, Lordship, the 50% did not deposit it. Without depositing 50%, Lordship, appeal has been admitted.
Appeal can be admitted. Is there any stay?
Yeah, it has been stayed.
Stay is there. Where?
Yes.
Stay lordship order dated 17/8/22.
In I number
In I number lordship 2394 of 22.
where is the order?
Order dated 17/8 of 20.
What order? Copy order. Do you have a copy of
Yes,
the
sir.
order?
I have a copy.
17/8.
17/8.
Good order. Get to be what I had to equal. You have to file an application. We'll modify this. Without an application, it will not be proper. So, uh, I have appearing for the claimants. However, submit that there is an order of stay, comma. There is no corresponding direction for any deposit, which has caused hardship, which has been causing hardship to the claimants. Para. The claimants are at liberty to file necessary IA for modification of interim order.
Lordship, both appeal may be taken together, Lord.
We have already said
Highly
after a week.
highly on this.
Today to hear huh? No, it's been
Highly.
last during the order. Yes.
As per last order,
Yes.
dated 28/6/2013,
Correct.
we have been allowed to take justice after the private respondent, considering the urgency of the matter.
Yes, yes.
And we have taken these steps by justice also, and it has been charged, and we have filed affidavit to that effect.
Affidavit is not there.
Affidavit dated 27/4/2023. Also.
It is not here.
May I produce?
You will have it on Friday along with the affidavit. To office note dated 27/2023 reflect that affidavit in support of the justice service has not been received by the section, comma, SK Goswami Learned Counsel for the petitioner submit that such affidavit was filed
On 24/7.
obviously after that date, on 24/7/2020. It is obvious that since the office note is of a prior date, comma, such affidavit was not there at that time. Please release this case on Friday. On Friday, along with the affidavit stated to have been filed on 24/7/2020.
Obligations.
Madam, what is this?
Yes. File a petition, my lord. For seeking my lord, permission to sell part of the property, my lord, in possession of the applicant, my lord. Actually, my lord, this is an RSA, my lord.
But there's an observation that the entire appeal will be heard.
Yes, my lord. Yes.
We'll hear the entire appeal.
Can it be on Friday, my lord? Because this was
Friday may not be possible. On Tuesday,
next Tuesday, my lord.
Next
Your
Tuesday.
lordship will be available, my lord.
we know through some code will definitely be there.
Because my lord, my urgency is what, my lord, that
understood.
she is
We-
suffering, my lord. The
we
wife
have
is suffering from cancer, my lord. And I see he applicant wants,
We can have it day after tomorrow.
yes, my lord.
After tomorrow, my lord? No, my lord.
Okay, Tuesday next.
Tuesday.
Tuesday next.
Other cases are fixed.
MD Chaudhary, Leonard, counsel for the counsel for the appellant, submit that in IA number 1665/2023, an order has been passed on 30/6/2023 that the matter was to be taken up for final disposal. The matter, no, the main appeal was to be taken up for final disposal.
Along with this one.
However, on 1970, it had not come over.
1970.
On 1970, 2020.
It was a leftover.
However, due to paucity of time, the matter could not be taken up. Put to para. List for consideration on Tuesday next. Just apprise this court about this order. We'll take it.
Can it be under my lord top of the list, my lord?
Cannot be difficult.
It will be coming under hearing, my lord.
It will come up to our orders, but we'll take it up as hearing. Just make a minute.
My
Yes.
Tomorrow, your lordship. Can it be on Friday, your lordship?
Which matter?
The item number 1, your lordship. I was in fact here, your lordship, but I have to go to the
Other side, somebody.
S. Das, SK Das.
Yes, SK
I will
Das.
inform him.
You have.
Lord, no, I will.
We can change the date, not an issue, but both of you have.
I will talk to him and then.
And inform. We can change the date, but without his consent.
I will take it.
My lord, item 18, if it may please be taken up on next Thursday.
We'll have the date.
May I please, your lordship,
Obliged.
item number 14 and 15 is electrification date. Date is occurred 2000. Kindly fix the matter, your lordship. Next Tuesday.
Item hearing matter.
Yes, your lordship. That's the only the instruction is given by the, yes, AD.
Oh, yes. We can have it day after tomorrow. Day after tomorrow. Electrician, ACB is there. Both two matters are there.
Yes, that's it.